This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
Joining us now is Todd Lutsky. If you have questions for Todd, whether it's about your estate plan, how it impacts your taxes, pending changes that could be going on. I know we've got the Trump tax cuts that are going to be ending in 2026. We've got debate over a Massachusetts higher estate tax. Todd has so many letters after his name that I can't even keep them all straight. But they can answer your questions. 888-205-2263 if you want to call the studio and talk to Todd. But Todd, let's start right off. When we are looking at an estate plan and when we are talking about what you see most commonly, what I see often is a very basic estate plan for maybe a younger couple. And I think that makes all the sense in the world, right? I just bought my first home and I need to get something done. And maybe, I've got a mortgage and, we aren't worth a ton of money. It's just, hey, I need a will. Why does that need to maybe adapt and change over time if all you have is a will for your estate plan?
Yeah, I think that's a fair question because, when we talk about mistakes that people make in the estate planning world, folks, and that's really where we are today. I want to discuss all the different potholes that exist in estate plans. So this is somebody who may have done an estate plan and you say, do I need help now even though I've already done an estate plan?
Sure.
Yeah, you still could. In this case, if you say, I'm relying on my will because I got my estate planning done because I did a will. Well, folks, I like to say that a will is really a won't because it won't do a lot of things. Let's run through that, right? So, one, a will doesn't avoid probate. Wow. Who knew, right? That's the simplest thing. Everybody says, I want to avoid probate. And you say, well, I got a will, therefore I avoid probate. No, you don't. Big mistake, because the will is the only item that acts, your only tool in your estate planning toolbox that goes to probate. A trust doesn't get filed. It covers all assets you own in your own name. And if you only have a will, I'm guessing that all the assets are owned in your own name, and so they're going to head to probate. Mm-hmm. So that's a problem and a mistake, a pothole people don't think about.
Maybe somebody's not all that familiar. Why is probate a problem? Just very briefly, and then I think, Tucker, we have a call coming in. So just why is probate such a problem, if you will?
It's usually a problem because of the cost.
Okay.
One, nobody wants to deal with costs. And two, it's time consuming, right? It's going to take, I would say at least 12 months to take you through the probate process.
Okay.
Yeah, so why do I want to go through this? And it's all public. It's all exposed to creditors. It's your whole family affairs are basically at the probate courthouse with an inventory of assets and the like. I mean, I'm just trying to hit the surface here of what it is. But hopefully that's enough reasons to not deal with that.
Eric in Springfield is joining us on the line. Eric, you have a question for Todd?
I do. I'm just curious if you know the tax implications. My father had passed and left me 1,000 shares of a stock that he bought at, say, $100, and now they're worth less. What are my tax implications on that?
So, interestingly enough, if you inherit an asset, which you did, because your dad died, your basis in that stock is whatever the fair market value was on the date of death, right? So if when he died, the stock was worth, I don't know, tell me, when he died, what was the stock worth?
I think it was worth maybe 110.
110, and that was how long ago? When did he die?
A month.
A month ago?
Yeah.
And what's the stock worth today?
I think it's at like 112.
Okay, so you have a slight gain, right?
Okay.
So right now, your gain, if you were to sell this stock, would be $2 per share, right? So, but that's good because your dad probably bought the stock for, maybe $10 a share, right? And when it was at 10, now it's at 1, and when he died, it was at 110. The good news for you is you're not stuck with his $10 basis. In my example, you got his basis, you got a step up in basis equal to 110 on the date of death, which is great for you. So you only have a small gain to pay if you were to sell the shares now.
Or Eric, was the reverse true? Did he actually pay more for it?
No, he bought some stocks at 3 different times. Like he bought it once at $200.
Jeez, wow, that's pretty rare, Todd. Where somebody actually doesn't get to take advantage of the step up in basis. It would have been more lucrative for his father to have sold it in his lifetime. That doesn't happen very often.
That does not happen very often, but that's really the situation.
Most times we're talking about somebody who bought a house in the 1970s and suddenly it's worth 10x what they paid for it. But this is one of those rare instances where the step up actually harms you rather than helps you.
Yep.
So
there you go.
Interesting. We're going to take a quick break here on the Financial Exchange, but Todd is going to be, I think you're sticking around, Todd, sticking around for us.
Ready for questions.
If you have questions for Todd on your estate plan, changes to what you're trying to do, changes to the legislation that could be coming down, call us, 888-205-2263. You can ask your question live on air. Again, that number, 888-205-2263. We'll be right back with Todd.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
We're back with Todd Lutsky from Cushing Dolan. If you have a question for Todd, you can call the studio at 888-205-2263. But I have a question for you, Todd. So let's say I did go forward and I did draft an estate plan, and maybe I even went further than just doing the basic will that you don't think really does much for you. I've done the won't, if you will. Done more than the won't. Now my life changes. Maybe I have moved, or maybe something else has happened. What are the life events in your mind, or maybe even just the period of time that's gone by, that really necessitate a review of the estate plan?
Yeah, I think a lot of people don't realize little things can mean a big difference in your estate plan. Let's say you move out of state and you go, say, I've been in Massachusetts, I'm now moving to Florida or up to New Hampshire or something, and does that matter? Well, it can. I would say you should definitely look, and in fact, if you do move out of state, like I'll give you a Massachusetts example. If you move out of Massachusetts down to Florida, let's say, and you have a house that you kept up here in Mass, which is not uncommon.
Sure.
And you got your house down in Florida. And you did your whole estate plan up here in Mass. Well, when you move, the first thing you need to do is change your basic documents. Your will, your health care proxy, your power of attorney, right?
Really?
And your HIPAA form. Well, mainly just your health care proxy, power of attorney, and will. Why? Well, and HIPAA form. And living will, those basic documents, because those are state-driven. They tend to have their own state language, their own state forms that they like to use. So change those. Now, your trust, on the other hand, you might not have to change that. The trust should be able to carry with you from state to state. Okay. Whether that trust is revocable or irrevocable, it will carry with you from state to state. Could you change the situs language of the trust, meaning I want it governed by Florida law instead of Mass law? You could, but you don't need to.
Okay.
Right? So it still tends to work when you do that. So the only other comment I might say is when you change like that and you say, let's face it, why are people leaving from Mass to Florida? Well, they don't want to pay estate taxes.
Yeah.
In Massachusetts. Remember, the exemption in Massachusetts is only $1 million. Now,
I ran into this with somebody recently who they had, for a long time, their primary residence right here along 128. They also had a rental property. They moved to New Hampshire.
Yeah.
They kind of wiped their hands in Massachusetts and said, we're good here, but I'm guessing not so much.
Not so much. The only way you can make it good here, and meaning we're not going to actually pay any taxes in Massachusetts, would be to take whatever real estate you own in Massachusetts and put it into a LLC. Otherwise, it is considered taxable in Massachusetts, even though you're a non-resident. So they will end up taxing you on the value of your real estate in Massachusetts as a percentage of your entire estate.
Hold on. What if maybe it's just a $500,000 home in Massachusetts and all my other real estate, all my other assets are outside of the state. Like, I live in New Hampshire. Maybe I'm worth $2 million. I've only got a $500,000 home. I'm not above the $1 million limit.
So
right?
what they'll do is you are, because it's $2 million. It'll take $500,000.
So they don't care what state it's in. They're looking at the whole value.
Whole value. $500,000 is the numerator. Divide by $2 million is the denominator. They're going to take a percentage of they'll come up with that percentage, and then they'll tax you on the $2 million and take only the percentage associated with the mass property. So, folks, that is what we call an estate planning pothole, right? There are so many estate planning potholes to avoid, and that is the name of our new guide for this month, folks, how to avoid these potholes in your estate plan. You think you've done an estate plan. I don't need this. Well, this is why you need it. Did I fund my trust? Oh, I'm not sure. Am I relying only on a will like you asked me earlier? I don't want to do that. Don't rely on a nominee realty trust. You think you have one. Remember, those trusts are really tricky, folks. That's not the way to go. What if you've moved? What if a spouse died? What do I do as a surviving spouse? Folks, there's potholes to avoid. If you've already done your plan, get the guide. If you haven't done your plan, get the guide to learn how to do your plan correctly. 866-848-5699. Or go to our website, legalexchangeshow.com. You can download the guide there. I think it's a great guide because it affects so many people. 866-848-5699 or legalexchangeshow.com.
Todd, talking of blunders and mistakes to make, you pointed out, hey, with only a will, you're going to probate. But there are multiple ways to avoid probate, from what I understand, right? I mean, I can name beneficiaries. I can put somebody on my account so that they can just take it over if I pass away. IRA accounts, right? Maybe I've got a 401k through work. It's almost standard practice that I name beneficiaries on those sorts of things. Do those go through probate too?
So, no, you're right in terms of avoiding probate. So if I only had a will, right, I could avoid probate even though I have a will. You're right.
Okay.
In the sense that if I've named designated beneficiaries on an IRA or named designated beneficiaries on a life insurance policy, or I've got a joint account with a family member on it. Yeah.
Sure.
Yeah, those would all avoid probate. But again, when I have a will, it doesn't, when I say a will is a won't, it doesn't reduce your estate tax liability.
Okay.
So naming all these beneficiaries isn't going to help you reduce your estate tax beneficiary. It is not going to protect assets from the nursing home if that's a concern of yours. So that's not being done. Yep. And really, how you're leaving it to your family might not even be accomplished efficiently if you do this. Because if you stop to think about it, if I left a bunch of my accounts jointly owned with one of my children, well, my other child's not getting it. It's only going to the child who's a joint owner. I didn't mean to disinherit my other children, but I guess I did because I only listed one on the account as a joint owner. So you got to be careful not to disinherit a child or a beneficiary by doing this shortcut method. So I think there's a lot more that can be done for you than just a will. A will just isn't going to do it.
Todd, we've only got about a minute left, but I hear this commonly. Hey, I don't have an estate that is big enough to worry about, this type of thing. And it depends where you live, obviously. But there's some things that aren't commonly counted when they're counting up their value of themselves. The primary residence comes to mind. But what really gets counted when we're talking about an estate, and what do people need to be thinking about?
Yeah, because when you're thinking about the size of your estate or thinking it's not big enough, remember, no one thinks about real estate. But what about life insurance? They think that's nothing. You don't think about it because it doesn't happen until you die.
Yeah, I thought it was tax-free, not estate tax-free, though.
And it may have no value today. It may be zero today, but when you die, it's worth $1 million. That's when they value it, folks, on the date of death, not the moment that you're looking at your estate plan. So all assets are included in your estate plan, folks. Think about it. You could easily be over $1 million. And if you're not, you might just want to protect your house from the nursing home. That would be reason to plan in and of itself.
Todd, as always, really appreciate it. Really appreciate your time, and look forward to chatting to you again very soon.
Always a pleasure.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.